Hi, everybody. This is Steve Maggi from SMA Law Firm. Welcome to Building the Bridge. And I have the privilege of being today with Chris Cavaliere, a partner at Shoemaker Law Firm in Tampa, an expert in employment law. Sorry, immigration's my thing. I wanted to talk about criminal background checks. How do you make sure that who you're hiring is, on the up and up? What do employers need to know?
Sure. So, and thanks for having me here, Steve.
Sure.
It's a pleasure. So, um, criminal background checks is an area that a lot of companies kind of get wrong because there are lots of complicated rules when it comes to conducting background checks. Obviously, a lot of companies run criminal background checks for good reason. In fact, if you don't run a background check, there are risks associated with that, right? Because you don't know who you're hiring,
Yeah.
and God forbid the person comes onto the job and it turns out that they've got 5 previous assault charges and they assault one of your employees. Now you got a negligent hiring claim on your hands, right?
Yes.
So lots of companies decide to do background checks. And the vast majority of clients that I work with anyway, they typically use outside vendors to run those background checks for them. Very rarely does a company do their own investigation, right? They don't have time for it. They can mess it up.
Yes.
So the takeaway here is that when a company uses an outside vendor to run a background check, they have to comply with a federal law called the Fair Credit Reporting Act, or the FCRA for short. And just a little quick disclaimer, I'm going to be talking about federal and Florida law here. Some states have their own background check rules, as you can probably imagine, but I'm going to be talking about federal and Florida law here.
Okay.
So again, takeaway is if you use an outside vendor, which most companies do, you have to comply with this federal law called the Fair Credit Reporting Act. This federal law has a ton of different requirements, but the one that a lot of companies mess up is that this federal law requires that before you run a background check, you have to give a very, very specific disclosure and authorization form to the job applicant. And the disclosure form, and the purpose of this is I'm disclosing to you that I'm going to run a background check. And then, of course, the purpose of the authorization form is you are authorizing me to do that, right? When it comes to the disclosure form, that I am disclosing to you that I'm going to do a background check, this federal law requires that this disclosure form have very specific language on it. And this comes to a surprise to a lot of folks. The federal law says this disclosure language has to be on a form that contains nothing but the federal disclosure, with the one exception being that the authorization can also be on that form. So what do I mean by this? What I mean is there are some hot button language that you should look at in your disclosure form. And if it's on there, it's pretty likely that you are violating this law.
So you're saying there's not a standard form that some employers might actually give potential employees a form with different language?
So there is no government sanctioned or issued form that I'm aware of. I know that I have a standard template that I help.
That would be good if they had one.
It would, but there should be a standard template that companies use for all of their employees. Right. But what do I mean by the fact that the disclosure has to be on its own form? It can't have any other language on it. That means that if your form has any state-specific language on it, what I see a lot of times is there will be a disclosure form that will say, we're disclosing to you that we're running a criminal background check under federal law. If you live in Minnesota, check this box if you want a copy of your report. Okay. If you live in California, X, Y, and Z. If your form has that state-specific language on it, not only have courts found that violates this rule that the disclosure has to be on its own form, but they actually find that this is so well entrenched in the law that if you do it, it can be considered a willful violation, which carries with it stiffer penalties.
Wow.
If your form has liability waivers or releases on it, for example, your form says something along the lines of, job applicant, you are authorizing me to contact your former employers and courts to get all of this information, and you are releasing us, the employer, from any liability that could arise from doing this background check. If your disclosure form has that language on it, again, courts are all over it. They say this is a willful violation, and it carries with it very stiff penalties.
Okay, when would this arise? When would this become problematic? So you're going to do a background check on someone. You end up hiring them, I guess, would be when this would probably come to fruition. What goes wrong that it brings us to a court, for example, and then this comes to light?
Sure. So the most common way is probably the most obvious one, and that's when you reject a job applicant based on a background check.
Okay.
And they go see a lawyer, and you get a nasty gram from them saying you violated the Fair Credit Reporting Act because you didn't give me the proper form. There are also other requirements on the Fair Credit Reporting Act, a different topic for another day, but they'll point to the form and say, hey, here's your form that you gave me, and it's not compliant with the Fair Credit Reporting Act. You've got all the state-specific language on it. You have a liability waiver and release. You violated the Fair Credit Reporting Act, and I've been damaged as a result. That's one way that this comes up.
Okay.
Another way is a more sneaky way that this comes up. And this is something that I've seen in my own practice. And there are firms in my local area that do this. There are plaintiffs' firms that have sort of made almost what I'll call a cottage industry out of filing class actions on this issue based on technical deficiencies in these forms.
Wow.
And what I've seen, and my partners have seen at my firm, is that we have seen cases that are your run-of-the-mill discrimination or harassment cases. And for one reason or another, the case settles, and the parties are engaged in trying to negotiate a written settlement agreement. And the plaintiff firm, and several firms have done this, the plaintiff firm will say, okay, great, we've got a settlement. The only thing that we need is we just want to take a quick look at your disclosure and authorization form for your background checks, and we'll be on our way, and we'll just sign that settlement agreement for you. And some employers maybe they don't have counsel who are helping them, or maybe they don't have counsel that specializes in employment law, and they will hand them over a copy of the background check form, not really thinking that it's anything significant. And then before you know it, you've got a class action lawsuit on your hands. And depending on how many employees you have, the look back period for these cases can be up to 3 years. It's typically 2 to 3 years. So just think about every job applicant that you have provided this form to. And there are statutory damages, there are attorney's fees. The penalties can be, I mean, you're talking 7 figures sometimes in these cases.
Sounds almost more dangerous not to hire someone than to actually hire them.
In some cases, it can be. I mean, I would definitely recommend to companies that if you're going to reject an applicant based on the result of a background check, I would absolutely recommend you speak with an employment lawyer before doing it, because there are a lot of trapdoors here.
Wow, that's really frightening, but very enlightening. Do you have any take-home lessons besides that one? That's a great one.
No, I think that covers it. Big takeaway is, I mean, almost before you take any adverse action against employees nowadays, but just keep in mind, a lot of employers they think this is a gimme. They think, oh, this, and I know we're going to get into this this topic in a deeper dive in another video, but a lot of companies think, well, this person's got a criminal record. This is an easy one. Of course, I'm going to reject this applicant because we got a hit on a criminal background report. And we're going to talk about that in a different video. But just on the procedural aspect of it, is the form that I gave this person correct? Or did I even give this person a form? That in and of itself, before we even start talking about what the crime was and how long ago was it, sometimes that process can be a violation if you haven't been careful.
Wow, very enlightening. Thank you so much for teaching me and our audience new things today. How do employers get in touch with you to make sure that they are doing their criminal background checks correctly, that they have the right language in the forms that are being signed, et cetera, to cover themselves?
Sure. So you can call me at my direct line, 813-676-7208, or you can email me at ccavaliere@shoemaker.com.
Great. Thank you so much for spending time with us today, Chris.
Thanks, Steve. It was a pleasure.